Introduction to International Law. Meaning of international law, ladies and gentlemen, international law refers to the body of rules, principles, and norms that regulate relations among states, international organizations, and other subjects of international law. According to LASA Open Aim, ladies and gentlemen, international law is the body of customary and conventional rules recognized as legally binding by civilized states in their relations with one another. What are the characteristics of the international law? Ladies and gentlemen, major characteristics of the international law are governs relations among states based on consent of states, governs relations among states based on consent of states, lacks a centralized legislature, lacks a world government, promotes peace and cooperation, regulates international conduct. Ladies and gentlemen, subjects of international law. Primary subjects, states. Secondary subjects, international organizations, individuals, multinational corporates, and national liberation movements. Ladies and gentlemen, importance of the international law: maintains international peace, reduces conflict among states, promotes cooperation. It means encourages diplomatic and economic cooperation. And point number three, protects human rights, provides international standards. Point number four, facilitates international trade. Ladies and gentlemen, creates legal certainty and promotes environment, addresses global environmental concerns. Ladies and gentlemen, what are the again we what are the importance of the international law? Ladies and gentlemen, it maintains international peace, reduces conflict among states. Point number two, promotes cooperation. Okay, international law promotes cooperation. It encourages diplomatic and economic cooperation. Ladies and gentlemen, it protects human rights. Ladies and gentlemen, it provides international standards and facilitates international trade, creates legal certainty. Okay, facilities international trade, creates legal certainty. Ladies and gentlemen, what are the major importance of the international law? Point number five is protects environment, addressing global environment concerns. Okay, I think international laws addresses global environmental concerns. Ladies and gentlemen, what are the sources of international law? Ladies and gentlemen, this is one of the most important examination topics. According to Article 38 1 of the Statute of the International Court of Justice (ICJ), the main sources of international law are primary source, ladies and gentlemen, international treaties, conventions. Point number two, customary international law. Point number three, general principles of law. Ladies and gentlemen, okay, including to Article 38 1 of the Statute of the International Court of Justice (ICJ), International Court of Justice. The main sources of international law are primary sources, international treaties, conventions. Point number two, customary international law. And point number three, general principles of law. And ladies and gentlemen, what are secondary sources? International treaties, conventions. Customary international law, international treaties, conventions, international treaties, conventions, customary international law. Okay, general principles of law. international treaties, conventions. We know uh, primary sources are international treaties and convention, customary rules, customary international law, and general principles of law. Ladies and gentlemen, secondary sources are also there. There, we know point number four, judicial decisions, ladies and gentlemen, and point number five, writing of eminent jurists. Okay, judicial decisions. Point number four. Point number five. Writings of eminent jurists. Okay, or prominent jurists. Writings of prominent jurists and judicial decisions. Okay, what is international treaties or conventions, ladies and gentlemen? A treaty is a formal written government. Agreement. Treaty is the formal written agreement between two or more states governed by international law. What are the main features, ladies and gentlemen? A written agreement, legally binding, based on mutual consent, creates rights and obligations. What are the types of treaties, ladies and gentlemen? Bilateral treaty between two states, example Nepal India Treaty, and multilateral treaty between many states. Okay, multilateral treaty between many states, Paris Climate Agreement, like as. Okay, what are the importance of treaty, ladies and gentlemen? Treaty maintain peace, promote cooperation, resolve disputes, regulate international relations. What are the customary international law? Customary international law consists of rules developed through consent, consistent state practice and accepted as law. Okay, customary international law consists of rules developed through consistent state practice. These are international law consist of rules developed through consistent state practice and accepted as law. Ladies and gentlemen, elements of the customs are state practice and opinio juris. Okay, elements of the custom are state practice, repeated and consistent behavior of states, and opinio juris. Point number two, behave that such practice is legally required. Okay, point number two, state practice, repeated and consistent behavior of states. Okay, and open use juris means believe that such practice is legally required. Okay, for example, diplomatic immunity, freedom of high seas. Okay, diplomatic immunity, freedom of high seas, prohibition of genocide. Okay, genocide and sovereign equality. Ladies and gentlemen, customary law applies even to states that have not signed specific treaties in many situations. Okay, a customary law applies even to states that have not signed specific treaties in many situations. We know general principles of international law. General principles are legal principles recognized by most legal systems of the world. General principles are legal principles recognized by most legal system of the world. They fill gaps where treaties and customs are absent. Okay, general principle, we know legal principles recognized by most legal system of the world, and they fill gaps between treaties and customs are absent. For example, good faith. States should fulfill obligations honestly, equity, justice and fairness, responsibility. Every wrongful act creates liability, and natural justice, fair hearing and impartiality. Importance, provides legal guidance, supports judicial decisions, ensures justice. Ladies and gentlemen, relation between international law (IL) and municipal law (ML). Relation between international law IL and municipal law ML. We know municipal law refers to domestic or national law applicable within a state, and international law governs the relations among states. What are the difference between IL and ML? We know international law and municipal law. International law governs states, municipal law governs individuals. International law, international scope, and municipal law, domestic scope, and international law, consent based, and municipal law, legislative authority. Okay, consent based international law, municipal law, legislative authority. Okay, it requires legislative authority, and the international law, international tribunals related are international tribunals, and municipal law are enforced by international law enforced by international tribunals, and municipal law enforced by national courts. Ladies and gentlemen, theories explaining relationship. Point number one, monist theory. International law and municipal law form one unified legal system that is explained by monist theory. Main idea is international law is superior. That is called monist theory. Okay. Without international law, we cannot make municipal law. That is monist theory. And we know the proponent of the monist theory is Hans Kelsen. Hans Kelsen. And we know there is dualist theory. Dualist theory. International law and municipal law are separate legal system, ladies and gentlemen. Dualist theory explains international law and municipal law are separate legal systems. Main idea, international law must be incorporated into domestic law before application. Okay? International law must be incorporated into domestic law before application. And proponents are tribal and Angelotti, tribal, tribal and Angelotti of the dualist theory. Ladies and gentlemen, monist theory, dualist theory. And we know Nepal's position, the constitution of Nepal generally recognizes treaty obligations. Okay. Treaty ratified by Nepal become part of domestic law through legal procedures. Okay. Treaties ratified by Nepal become part of domestic law through legal procedures. What is international law and state consent? Ladies and gentlemen, state consent refers to the willingness of a sovereign state to state consent refers to the willingness of a sovereign state to accept legal obligations under international law. Ladies and gentlemen, what is importance of consent? Ladies and gentlemen, sovereign equality. States are legally equal, ladies and gentlemen. Voluntary acceptance. States voluntarily assumes obligations. Treaty formation. Consent is essential for treaty validity. Ladies and gentlemen, importance of consent. Sovereign equality. States are legally equal. Voluntarily acceptance. States voluntarily assume obligations, and treaty formation. Consent is essential for treaty validity. Ladies and gentlemen, forms of consent. Point number one, signature, initial agreement, ratification, formal approval, and accession, joining an existing treaty letter, accession, 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 joining an existing treaty letter. Okay, what is the principle, ladies and gentlemen? Pacta sunt servanda. Agreements must be kept. That is the major principle, ladies and gentlemen. This is the foundation of treaty law. Okay. What is the foundation of treaty or principle of treaty formulation or treaty law? That is pacta sunt servanda. agreements must be kept. Ladies and gentlemen, there are some criticisms. Some scholars argue that many international obligations arise without explicit consent. Many international obligations arise without explicit consent, especially customary law and jus cogens norms. Ladies and gentlemen, some scholars argue that many international obligations arise without explicit consent, especially customary law and jus cogens norms. Some scholars argue that many international obligations arise without explicit consent, especially customary law and jus cogens norms. Okay, what is codification of international law, ladies and gentlemen? Codification refers to the systematic collection, organizing, and written formulation of international legal rules. Codification refers to the systematic collection, organization, and written formulation of international legal rules. Objectives: clarity, make rules clear; uniformity, ensures consistent application; and legal certainty, reduces ambiguity; and development, promotes progressive development of international law. What are the main institutions responsible? International Law Commission, ladies and gentlemen, it is established in 1947 under the United Nations. Ladies and gentlemen, major achievements of the codification. Vienna Convention on the Law of Treaties, codified treaty law, and Diplomatic Relations Convention 1961, codified diplomatic immunity rules. Law of the sea developments contribute to maritime law codification. Advantage of the codification: predictability, stability, consistency, better dispute settlement. What are the challenges? Different legal traditions, political interests of state, rapid global changes, and enforcement difficulties. Ladies and gentlemen, open aim. We know open aim is the international law definition, foundation father of the international law. Open aim, and we know Hans Kelsen, monist theory. He presents monist theory and triple and Angelotti dualist theory. There are imminent of the triple and Angelotti are the imminent of dualist theory. Thank you so much.